Good afternoon, members. It's now time to start. We've also formed a quorum, so I call to order the meeting of the panel on administration of justice and legal services. Since the last meeting, a paper has been issued, namely CB bracket 2722/2025 bracket 01, an information paper provided by the Law Society of Hong Kong on the recent development of solicitors practicing as a solicitor corporation. If you have read the paper, this is mainly a response to the questions raised at the last meeting, and we also told about the future development. So perhaps it will be a bit disappointing. It looks like that it will require a little bit more time, but still we hope that we can start the legislative process before the end of the current term. And then items for discussion at the next meeting. We are going to hold our next meeting on the 2nd of June, a Monday at 4:30 p.m. In the light of the proposals from the judiciary as well as the administration, the panel has initially come up with the following agenda items. First, waiting times for the court proceedings. Second, pilot scheme on community mediation or mediators. Do you have any requests to speak? No? Then in that case, we move on to the third item on the agenda. Law Reform Commission Secretariat progress on the systematic review of statutory laws of Hong Kong. I would like to invite the administration to join us. And for those members who would like to speak, please press the request to speak button. Well, please refer to papers CB bracket 2674/2025 bracket 03. That's from the Law Reform Commission Secretariat. Our Secretariat has also come up with a background brief, and that's paper CB bracket 2674/2025 bracket 04. I would like to invite Mr. Paul Lam, SC, Secretary for Justice, as well as Chairman of the Law Reform Commission of Hong Kong to speak. Thank you, Chair. Thank you for the panel to give us the opportunity to report once again the progress on the systematic review of statutory laws of Hong Kong by the Law Reform Commission Secretariat. We're still focusing on the priority area, that is adaptation of laws. Well, in December 2024, we last reported to you. Only 4 months have lapsed. But then in the light of what happened earlier this year, in fact, we have already submitted a 2025 bill. So it is the right time to report to you the latest progress. We always want our laws to be up to date and in line with the constitutional framework of one country, two systems. Would like to be a place governed by the rule of law. We'll continue to have a systematic review of the statutory laws, focusing on 3 areas: adaptation of laws, consolidation of laws, and repeal of obsolete laws. Well, in 2022, the Secretariat embarked upon the task to do this, and we have been achieving a lot of success. So, in fact, we can say that we have already covered 157 pieces of legislation when compared with last year when we last reported to you 7 more. Well, of course, there may be more enactments or provisions or subsidiary legislation that have to be examined in the process. But we believe that a majority of them have been, as a result of the hard work of the bureaus, been identified. We attach a lot of importance to the work of adaptation of laws. We will start with the easier ones first. different responsible bureaus and departments have been very cooperative, and they have been issuing drafting briefs as early as possible. Last time we said that 57 pieces of legislation or subsidy legislation have already been adapted via 11 pieces of legislation or satisfactorily dealt with in relation to the problems identified. In January this year, we submitted the company's Amendment Number 2 Bill 2024. One piece of legislation has been identified, and another bills committee is looking at it. And then, by way of a future omnibus bill, will be moving the bill on behalf of the bureaus and departments, so that we will covering the legislative amendment process for minor amendments. And then last year, a bill has been passed by the LegCo, so we have gathered the experience. And recently, we've introduced the Statute Law Miscellaneous Provisions Bill 2025, covering 41 such pieces of legislation. And then there are also others that will be repealed directly because they are no longer up to date. We hope that the latest miscellaneous provisions amendment bill will still have your support. As to the provisions of references scheduled in different pieces of legislation, we will continue to examine them, and whenever possible, we'll like to move another omnibus bill in 2026. 44 pieces of legislation will have to be adapted. We are seriously considering their inclusion. We hope that the policy bureaus involved will take the opportunity and come up with drafting instructions in time. But then there will be other more complex issues, and we cannot move an omnibus bill to cover such. The Secretariat will actively gather together the different bureaus and departments, and then our drafters will also be liaising with them closely and will provide the assistance they need, so that in good time they will either have their own bills or they'll have a composite bill so as to move the amendments. We have to emphasize that the bureaus and departments have to make their own decisions as to when and how the amendments are to be introduced. And in fact, the Law Reform Commission Secretariat has tried to categorize the different provisions. We hope that we can continue to enhance the speed, and please have a look of paragraph 7 in relation to the categorization. And then in Annex B, we have also given you an idea about the number of pieces of legislation involved. So in Annex B, you can see that, as we have covered in our previous reports, provisions of subsidiary legislation identified has increased in the number, but then the number is decreasing. And with the resolution of the bureaus to issue drafting briefs as early as possible, we aim to complete the task before the end of the current term of the administration. I think you all know that adaptation is no simple task. It isn't a matter of a simple sort of replacement of certain words. We still have crown or the reference to Her Majesty. So sometimes it's not possible to have a mechanical replacement to replace a particular word by another one automatically. There are a few points to note. In the course of application, we have to look at the original policy intention. Second, we have to see whether there will be fundamental changes to our policies. And then we have to be detailed in our examination to see whether this is in line with the constitutional order of one country, two systems, and whether it is in line with the original intention of the NPCSC. And thirdly, for the application of laws, will it affect other legislation? So we have to make sure that it is in line with the common law and the statutory law. And we have to make sure that when it comes to the operation, there won't be any implementation difficulties. Sometimes overseas or abroad, or territory or territorial waters may appear to be simple words, but then there may be sovereignty implications, so we have to be very cautious. And together with the Legislative, we have been driving the work of adaptation laws. We have gathered a lot of experience, and therefore we can be quicker than in the past. As mentioned in the past, if we have to have there are also nine. Please take a look at paragraph 9. There are some difficulties that have been identified. Sometimes they're interrelated or they're cross-references. Sometimes we need to have input from different bureaus and departments, and we need to look at the impacts on all the departments. And then sometimes we may have to consult with the central authorities or parties outside the government. Therefore, when the bureaus are to drop the proposals to amend the remaining legislation, we need to be cautious. And if needed, we have to consult other bureaus, departments, and get the legal advice needed. And if it involves the central authorities or if it involves the relationship between the central authorities and the SAR, we have to consult the central authorities before we can make a final decision. In fact, our drafting division will keep up a dialogue with the central authorities to make sure that we're moving in the right direction, and then we can have early identification of the difficulties. While we're adapting the laws, repealing the obsolete provisions has been commenced. 16 pieces of such have been repealed. Another 28 ordinances or subsidiary legislation will also be covered by the Statutory Law Miscellaneous Provisions Bill 2025. 16 others have been identified as obsolete, and most of them will be taken care of by a future omnibus bill. The Law Reform Commission Secretariat will continue with the task, and every 6 months we're going to come back to you to give you a report. But as I have always said, before we can have any concrete plans, the LRC Secretariat cannot sort of make an announcement ahead of the Bureau's announcements. Myself and my colleagues will be happy to answer questions from you. Thank you, SJ, for your introduction.
5 minutes, questions and answers included. First of all, we will have the Honourable Jimmy Ng. Chair, I very much understand that the laws are interrelated. You cannot change just a few words in a particular ordinance without affecting other pieces of law. Now, given the situation, and there are given the number of pieces of legislation which have been proposed to the panel from the Law Reform Commission Secretariat, I applaud that. Now, when we're talking about obsolete laws or adaptation of laws, in your work, what would you consider? For example, for national security law, now that it is commenced, my question is, how would it affect your work in terms of the number of pieces of law that would be adapted because of the passage of the national security law? Essie? Well, Chair, actually, when the Article 23 came into legislation, we had already looked at the ordinances, including where there are related pieces of law. Well, basically, last year, that is, we have already handled this. That is to say, the answer is this had already been done. This had already been considered. Next, Priscilla Leung. Chair, first of all, I would like to confirm that the present term of government had already started this systematic review of statutory laws of Hong Kong. This is the first time we have started with this work since our return of sovereignty 25 years ago. And we see that the progress is in process. Now, just now I noticed that the Secretary said that the adaptation of law, the work would be completed by the end of the term of this government. So that is by 2027, right? So there'll be 3 more lots coming to this panel. Is that true? From now to 2026 and then 2027. Now you have come to the panel with the second lot. So is my understanding correct? So how many pieces of legislation is still to come? That's the first question. Second question, because I know the difficulties that you have pointed out. I was in the committee as well for the last round of adjustments. Now, for some of the legislation which contains certain bureau which have not been existence since perhaps 1989, and they have not been taken out. Now, given that there is technology, AI, DeepSeek, etc., would it mean that all our legislation would be made online? Well, I remember in the year 2000, we have made it electronic. It's been 20 years or over since. So through these search engines, perhaps I can help with your work. You would perhaps have certain consolidated records. For example, some of the bureau which are no longer in existence would be taken out en masse, things like that. So my question is, can we use technology to promote the work of the various bureau in dealing with the obsolete legislation, because if it's not dealt with, it would not be in keeping with the progress of time. Well, Chair, the ultimate goal is to complete the adjustment work before the end of term of this government. Now, first of all, there is the omnibus bill route, and we've looked at the legislation and where these are straightforward without much controversy, and where the policy intent is clear, then we will batch them together as omnibus bills. And our intention is in 2026 there will be another omnibus bill introduced. So perhaps there will be another 40 pieces of legislation or so. We're pretty confident that this will be included into the omnibus bill, but for some others, they are not as straightforward. The straightforward ones will be contained in the omnibus bill. The others will have to be dealt with one by one individually. Perhaps there are some policy perspectives which must be duly considered, or consultation with the central authorities, etc. So it's very difficult to pin down the exact time. But for me, as the person leading the entire effort, I have a target set for myself. And this target had already been shared with the Policy Bureau. So whatever the final number of pieces of legislation is, we are working towards that timeline. So the second question was on technology. Have we been using technology? Yes, we have. Apart from AI, we are using search engines. And our stance is not to be passive and wait for the bureau or government to tell us, but rather we are proactive. We sweep through the legislation, and when we're considering one piece of legislation, perhaps we would realize that there would be others which are related, or perhaps we have not dealt with another piece of legislation which may well be related. So yes, we have been using technology where we can, and we've been consistently doing so. Thank you, Secretary. Do you have regular intervals whereby you have a staff member who would liaise with the Law Reform Commission and the relevant Policy Bureau? Chair, yes, indeed. I've set up a mechanism where Wesley, the Secretary General of LRC, would have regular meetings with certain seniority officials of the relevant policy bureaus. For some bureaus, there are more legislation related, some less. I myself have sat in such a meeting. And basically, there would be a point-to-point liaison between the RRC and the Policy Bureau, and that would be more effective in handling the work. Next, Carmen Can. Thank you, Chair. I very much welcome this Omnibus 2025 bill. In this term of the SRA government, in the systematic review of statutory laws of Hong Kong, in terms of the progress, it is exemplary. For example, in 2024, there was one omnibus bill, and then there is this 2025 one. And for the legislation of Article 23 of the Basic Law, the adaptation of local laws had already been done, as we have heard from the Secretary. So that is very effective indeed. So there's been 2 rounds, and then there will be another round. And I'm so glad to see that my proposal or suggestion before had been adopted. And as the Secretary had mentioned, so some of the easier and more straightforward legislation are being dealt with, and the more difficult ones will be left to a later date. So that is a mechanism, and with the mechanism, there is regularity and also officials specifically tasked with this work. And there is liaison with the Policy Bureau as well. So I commend this, and this is very effective, and I do want to see this come to pass as soon as possible. Now, specifically, I'm looking at the paragraphs 58 to 61 concerning the law's adaptation. I would like to know how those are being dealt with in terms of the miscellaneous provisions. So for the mainland of the PRC is referred to the mainland, and Taiwan calls it Dailok in Chinese. And so in the laws, there's certain terminology, basically in Chinese, Dailok, which will have to be changed to mainland in the laws, consistent with the terminology. And MACAU, that is a spelling for Macau, but there are certain instances where this is spelled MACAO. So will that be made consistent? What are you referring to? Ms. Carmen Can, what are the paragraphs 58 to 61? Yes, I'm referring to the paper. I'm referring to the annex, paragraphs 58 to 61, or item 68 to 61. Well, actually, Ms. Can is referring to the bill. She's actually referring to Annex B of the bill, Chair. I'm sorry, Chair, but my question is still relevant. Sorry about that. Right, Chair, perhaps I can throw some light on it. So basically, it is on the 2 terms, mainland and Macau, the spelling of the latter in particular. So for spelling of Macau, even though there are exceptions, but mostly they are spelled M-A-C-A-U. And this is a Portuguese way of spelling Macau. Before the changeover, Hong Kong law would adopt this Portuguese spelling, M-A-C-A-U. And we'll make this consistent this time, because for the Macau SAR government, for their English version official documents, they use MACAO, which is the English way of spelling. And for the country, they also adopt the English way of spelling as well. So, of course, we draw the line. We cannot deal with all the legislation this time, but basically we are changing the U to O consistently, so adopting the English mode of spelling rather than the Portuguese one. The other question was on mainland and dialogue. So 內地 and dialogue in Chinese. So we have adopted the 2024 method as we go through the legislation where there is the Chinese term dialogue. We will look at whether this is about China and Taiwan or whether it is China mainland versus Hong Kong SAR. If the latter, then we will change it to 內地 in Chinese rather than dialogue. So that is a guiding principle. Chair, just a follow-up question. Apart from building the mechanism, I'd like to know, is this related to e-legislation progress? So e-legislation work has kicked off. Would that help with your work here? Chair, in the then LegCo, the legislation that are passed, when we put them onto the website, they were confirmed. They were fine. And now we will look at the legislation in their present presentation. All these are put onto the internet, and we are very quickly able to know how the present legislation make the presentation. And that will be the basis where we scan through the legislation where there is need for revision or adaptation will come to the LegCo for adaptation before they can go onto the electronic legislation webpage. Right, Chair. Yes, we would want to see more technology used in scanning of the legislation. We thank you for the answer. Next, Maggie Chan. Thank you, Chair.
I'm grateful to the SJ as well as the LRC for the hard work. They have clearly spelled out that they hope to finish the task before the end of the current term government. I do respect their objectives. I believe that the legal sector as well as the lawmakers are glad to get this from the administration. We all hope that you can soon complete this historic task. Let's go back to paragraph 9 of your paper. Mention has been made about the areas that you are working hard. Let me look at point C. It is said that sometimes you need to consult the central authorities as well as parties outside the administration. Let me focus on the central authorities. I know that you do have regular liaison sessions with the central authorities, but this has to become formalized. My question is, when it comes to your communication, do you have any regular communication mechanisms with the central authorities so that you can consult the advice of the central authorities? Would you consider that for the purpose of the adaptation of laws exercise, that is, while we try to decolonize our laws, would you try to come up with a platform and establish a channel so that you can take the initiative to decolonize the laws so as to do it in advance and try to deal with it effectively? Of course, I'm not talking about the laws that have already been enacted under the basic law and that has been that have been reported for the purpose of putting it on record. So I want to know whether you will take the initiative to consult the central authorities, and do you have a channel? I think it's a matter of the institutional setup. Let me be clearer in my explanation over 2 points. First of all, sometimes there are complex issues. Indeed, we have to consult the central authorities, be it the Hong Kong Macau Affairs Office or the Liaison Office. We do have a direct counterpart over this matter. The central authorities take this matter seriously. Wesley does communicate with them regularly, and in fact it has been much more effective and efficient than in the past. We're able to get their advice directly. As to the difficulties in the past, different departments and bureaus are dealing with different rules, regulations and legislation. They approach the central authorities separately, so it wasn't that efficient. Now what we're doing is that we take the lead. Whenever possible, we try to gather the needs of the departments and bureaus, and then in one go we try to approach the central authorities, and this way we can save their time, and then the responsible officers can find it easier. Otherwise, today a particular bureau will consult them for a particular point, and tomorrow somebody else will also ask the same question again. It's easier when we try to collate and consolidate the questions raised, and in this way we're able to make it more efficient and we can save time. So this will be the mode that we adopt in the future as well. Of course, the amendments must be in line with the basic law. This is already implied and it is necessary. If I may also raise one other question. Well, we have already enacted the national security law. Well, for central authorities, we have got a broader definition for that term. Now, for the adaptation of laws, we are decolonizing our laws. I want to know whether in this exercise, would you also consider the same issue? Of course, in the case of Article 23, we asked the views of the central authorities, and we were given confirmation about the definition of the term central authorities. Now, for laws with the same background should be consistent, but we cannot rule out the possibility that there may be special considerations elsewhere in other pieces of legislation. Now, in this case, of course, we are aware of the need to define the term central authorities. Thank you, SJ, for your reply. I'm raising this point. I simply want to make sure that for the term central authorities, it will not be confined to the NPCSC, the President, the Central People's Government, the Central Military Commission will also be covered. So vis-a-vis the past definition, before the adaptation, in particular before the return of Hong Kong to the motherland, it would have been very different. So I just wondered if you would revisit this topic. Let me defer to Wesley. Thank you, Ms. Chen, for your question. I think members will still recall that when the LegCo scrutinized the national security law for Hong Kong, the NPCSC, in the form of FAQ, provided answers to 2 questions as to what is meant by the central authority. And this has been applied to the Article 23 legislation. As to that's in one of the questions. As to the reply to another question, it is clear to say that we have to look at the Constitution, the basic law. We have to look at each and every provision and the relevant meaning. Therefore, we have to make reference to the NPCSC's Q&A, but at the same time, we need to understand the content and the purpose of individual provisions, and then we have to talk to the relevant bureaus and the actual department having to enforce the relevant provision. We have real life examples. Say, for example, for the fixed penalty tickets for illegal parking, there was an amendment. When we talked about central authorities' vehicles, we have a specific definition. This was after consulting the central authorities were able to identify the most appropriate reference. But that's for the purpose of fixed penalty tickets for the time being. On other occasions, we have got full consultation with the central authorities, and if bureaus and departments find that it is okay, then they will issue the drafting instructions, and eventually they will be reflected in our laws. Well, as to the idea of having a regular liaison mechanism, I was told that you talk to the Hong Kong and Macau Affairs Office as well as the liaison office. But then for decolonization, it is a matter for the central authorities, as Wesley and other experts have already confirmed this. Now, for the mainland and for Hong Kong, given the constitutional order, the central authorities will make sure that our laws are in line with the Constitution. I am floating an idea for your consideration. Well, for the NPCSC, they have a Constitution and Legal Affairs Committee. Would it be better if you approach that committee as well? Because that committee is responsible for making sure that everything is in line with the Constitution throughout the nation. For us to have this decolonization, being in line with the Constitution is an important element. So would you consider my suggestion that is you go to that committee? That's the best approach in my mind. If I may also add to the discussion, I think it's a very interesting discussion. Currently, the term central authorities, 中央 in Chinese, may imply different things in different pieces of legislation. Am I right? Well, Article 160 of the Basic Law on the 23rd of February 1997, the NPCSC gave an explanation. That is whether it means the Central People's Government or whether it means the relevant organizations or whether it means the organizations stationed in Hong Kong. We have gathered experience in adaptation of some of our laws. So it all depends on the actual operation. That is, for the Crown, prior to 1997, for that term, it was difficult to grasp the meaning because it might not have a very concrete idea. But post the return of sovereignty, given our constitutional order, we have to identify the corresponding organization to reflect the concept, and that's the difficulty. What we want to do is that we hope that we don't have to rely on the decision made by the NPCSC on the 23rd of February 1997, so that we continue to rely on Schedule 8 to Cap 1 to apply the principles for the construction of the provision, so that in future we can be clear when we refer to the provisions. That's our ultimate goal. Next, Ms. Eunice Yong, the Deputy Chairman. I give recognition to the work of the LRC. This is already the 6th report. I think the progress is good, and soon the SJ in the year 2026 will move another statute law miscellaneous provisions amendment bill. Well, it shows that the administration has full cooperation among different departments and bureaus. The SJ has also mentioned, and it's also found in the paper, that they will do more to make sure that bureaus and departments will cooperate with the LRC Secretariat. I think it is important. In particular, please go to paragraph 10. It is said that you hope that before the end of the current term, you can complete the task, provided the bureaus and departments are quick in issuing the drafting instructions. Well, I know it is difficult, and since they may have changes in their setup, well, I think departments and bureaus have difficulties as well. It is important for them to hand down the administrative memory, so to speak, so that the exercise can be expedited. We are result-oriented. I think this is common as an objective among departments and bureaus. Now, for the SJ, I want to note about the difficulties faced by the LRC Secretariat. Do you think that technology can help so that you can move quicker? Members have also made suggestions in screening the legislation so that we can consolidate laws, we can repeal the laws. You can use technology, and in fact, among departments and bureaus, I think they can also equally rely on technology to expedite the task, so that the LRC Secretariat will find it easier to follow up on the work. Well, let me answer the first question. That is how we can be sure that there will be better cooperation with departments and bureaus. Well, there are 14 policy bureaus which are involved. They must each have their own directorate grade officer to be our direct counterpart. And should there be a change of officers, they have to tell us. So all of them must identify a specific point of contact so that we know who to go after, and this person will have a full oversight. And when we want to have a follow-up, we know who to go after. Well, use of technology. Indeed, we did deploy technology, but then for the outstanding issues, I'm afraid technology may not be that helpful. Technology can help us as to which terms are obsolete, but what is outstanding is that it's not so much a matter of whether we have identified the need to change. It's a matter of how to change it. We need to find out about the original legislative intention. Is it still relevant? Should there be changes to our policy? Sometimes in the case of adaptation, the change of a term may touch upon the rights and obligations, etc., of the central authorities. So we need to look at that, and we have to develop a mature idea first before we approach the central authorities. It takes time. So as to whether technology can help, I'm not quite sure, but technology can help in the initial stage.
Thank you for the answer. So, Junius Ho, first round of questions. Thank you, Chair. This is very proactive and progressive, and I'm in support of it. But when will you complete all the work? All the numbers you have given, and also in Annex A, there are 157 pieces of legislation, and there are some others as well. I also note in paragraph 11, you say that you want to be able to come up with the statute law, Miscellaneous Provisions Bill 2025. Now, where it is possible, in 2026, there will be an introduction of another omnibus bill. So this is a promise, but it's an empty promise. 150-odd pieces of legislation. I know you work very hard, but I always say working hard comes to naught. I just want to know when you're going to complete all the work. As a member of the Hong Kong citizens, since 1997, we've had many different secretaries, and they all tell us they have difficulties. But in paragraph 11 and 12, it's carved in stone. You say 2027, you complete all the work. I just want to give you some motivation, some encouragement, Secretary. Yes, you work very hard, and can you commit to this date? And then you said just now, what about the policy intent for the legislation? We have to look into that. Well, how long will that take? 28 years we've taken. Another 28 years we need. So there's 50 years of unchanged. Do we want to extend that? Well, Secretary, I do not doubt your sincerity and your hard work, but it's not good enough. As boss, it's very simple. You know, by 4 p.m. tomorrow, you have to hand me the report. Otherwise, you do not get off work. And in your report, there is no commitment to 2026 or 2027. And then you also point out that there will be omnibus bill coming to the lecture in 2026. Maggie, will you be here then? I may not be here if it drags on. So this is my point. Right. So Junius Ho is saying you have to be specific, perhaps giving the date and the month of completion of your work, maybe. Chair, actually, I've responded to a similar question. The DOJ or myself do not make empty promises. This is very specific. Within this year, 2025, there will be an omnibus bill and there will be a first reading. Whether it will include 44 pieces of legislation, we're not sure, but it will come. And also in paragraph 10, we have already said that our target is very clear, and that is to complete the exercise by the end of this term of government. But I alone cannot complete the work. I need cooperation from the Bureau. So my work is to lead the effort and coordinate the efforts. And the term is very clear. As for who will remain in the next term of government, nobody knows. But this is a very clear target of mine. Definitely not an empty promise, but very clear indeed, this target. Next round, Priscilla Leung. Thank you, Chair. Well, just now, the Secretary at the start had already said that the target is 2027 completion, and we're all working towards that target. And I believe that this work exercise can be done by the end of this term of government. Now, I remember in the last lot of adaptation of laws, I've asked this question. In the basic law, central authorities include the Central People's Government, the NPC, the State Council, etc. So in defining central authorities, there are different entities with different functions. In amending the basic law, for example, there would be the standing committee of the NPC, etc. But when you're referring to this chief executive, because it is executive role, it would be differently referred to. So we have to define the role in the overall constitution of the PRC. So it should be clear with understanding of the context. So we cannot ourselves in Hong Kong arbitrarily define central authorities because there is context to it. And further, the Basic Law Committee, etc., had made discussions, and that is after handover, all the laws of Hong Kong SAR, including the laws that we are dealing with in the adaptation exercise, these will be filed with the NPC. And you don't have to apply for it. They will definitely automatically review it. And so far, they've told us there had not been any contribution intervention of the Basic Law, Article 17, bracket 3, for the relationship between the central government and the Hong Kong SAR. So for this lot or batch of the adaptation of law, if you have filed with the NPC and they have not spoken against it, then it's fine with them. And another point, and that is in terms of terminology. If it is vis-a-vis Taiwan, the Chinese dialect should be used. But for where it's vis-a-vis Hong Kong and Macau, 內地 in Chinese should be used to refer to the mainland. So I don't think all mainland should be changed to 內地. Well, actually, my PhD thesis was on the conflict of law between the mainland and Hong Kong and Macau. And so that is the context. I just want to make a point of supplement here. And another further point is that I remember very clearly that there was a use of the terminology of Laos, and basically that was changed back to Lo Wo, which is the official name for the country, for the PRC. And so we have to remind ourselves internally in the government. Sometimes you would give us reminders. And now that this is updated, but actually we found that Liu Guo as the Chinese for Laos was still being used in the legislation as of last year, and it was only updated afterwards. So this is very interesting. I think I just want to raise that as a point of supplement, and we understand why some of the terminology need to be kept unchanged and why some of them have to be changed. Actually, in the last round of meeting, we have discussed the same. So this is just a point of supplement information. Wesley, want to respond? Chair, thank you. And we thank Professor Leung in pointing out the example of Laos. Yes, this is a foreshadow of the work going forward because there are certain legislation referring to currencies. Euro, for example, is used, but for some of the currencies that were used by certain countries before the euro was introduced, these are still mentioned in certain legislations as well. So we will be dealing with those as well, because after the EU, with the introduction of the euro, the domestic currencies have been discontinued. Chair, exactly. This is the difficulty because the regulations have been changed and times have changed. Will there be, let's say, mention of Bitcoin, for instance, where things are obsolete? Will you also use the opportunity to talk to the Policy Bureau to make the changes as well? Well, Chair, definitely we see something that's obsolete. We will, of course, raise them to their attention. It's only commonsensical that we will do so. The policy bureaus are the principals, and therefore they have the responsibility for their own legislation, perhaps not related to legislation adaptation, but where we notice certain points such as obsolescence, we will point it out to them. And of course, we will not leave it to another time and waste time and energy. Of course, we will point it out to them. Right. Through the Q&A, we know that the work of the government on the systematic review of statutory laws of Hong Kong is going on well. So next we go to agenda item number 4, which is the cultivation of international first-class law firms and arbitration institutions. Would the team please come into the room?
有兩份參考文件嘅，一份
There are two papers. One, CB bracket 2, 674 bracket 2025 bracket 05. And another one, which is the CB bracket 2 737 bracket stroke 2025 bracket 01 on Chinese enterprises using Hong Kong legal services, a survey. Yes, I will introduce you when you're asked to speak later. Now let us have the Secretary to bring us through the introduction. Well, thank you very much for the panel in inviting me and my colleagues to this agenda item to discuss and to hear the views concerning the cultivation of first-class law firms and arbitration institutions. I just want to talk about the SJC's work in cultivation of legal professions and also the cooperation of Hong Kong, the GBA, and thirdly, the training of and legal cooperation in the GBA. Now, the two organizations, the Law Society and the Bar Association, are tasked with self-regulation, including in continuing education and practice, conduct, discipline, examination. They are vested with the power to regulate solicitors and barristers on this. And they these self-regulatory regime with the regulations initiated by the legal profession will have to have gained the approval of the government and gain the consensus of the legal profession. In order to have one country, two system to live to out its advantages and the bilingual legal system, we have set up the academy, which uses the bilingual legal system and the one country, two system to consolidate Hong Kong's position as a hub for international legal service and arbitration, and to work with the Belt and Road countries, and to provide training for the relevant countries. For example, this year we have co-organized the program for national training course for talents handling foreign-related arbitration, co-organized with Ministry of Justice, and also the Hong Kong Common Law Practical Training course, co-organized with the Supreme People's Course of PRC. And the Academy also co-organized the Conference on Climate Change with Ang Citral in March of 2025. And the Academy will organize a mainland civil and commercial legal practice training course in 2025 in June, and also in September for the ASEAN countries there will be seminar on criminal law targeted for the Association of Southeast Asian Nations legal practitioners. And in nurturing legal professionals, this is very proactive. And at the same time, in May of this year, the DOJ will organize the forum for this will be held in Xi'an to introduce Hong Kong's international legal service and arbitration service. The response have been very positive, and we continue to proactively promote Hong Kong's international legal service and arbitration service. As for the Greater Bay Area, through the professional practice examinations, after passing those, the lawyers are able to practice in the GBA, including non-litigation work. There had been 550 such lawyers which have already been given the license, and they are able to serve the companies, including foreign companies that are going into the GBA and also GBA companies coming out. So for the development of the legal sector, we continue to promote that. Hong Kong is an important legal hub, and in particular in the GBA area, we promote our legal service as well as arbitration service to increase the ability of the organizations and the corporations, and also providing more flexibility for the enterprises to choose Hong Kong as a legal service center. Starting from the 14th of February, from Shanghai, it has already extended to Zhuhai. And for the Hong Kong invested enterprises to adopt Hong Kong law, and also with the benefit of the extended measure of China's Pilot 3 free trade zone to the 9 mainland cities, we're able to benefit from that. Now, for the arbitration organizations nurturing,
well, in fact, we have become the preferred site of arbitration. For many years, the DOJ welcomed arbitration organizations to set up offices in Hong Kong. We would like to facilitate the provision of mediation and arbitration services in Hong Kong. In fact, we have set up the legal hub in the central business district. Many organizations have set up their offices here. We have a number of them, and in fact, like the AALCO, etc. We have also got the International Court of Arbitration of the International Chamber of Commerce Asia office. Well, in fact, the arbitral rules have been taken seriously. Well, in fact, Hong Kong and Singapore are regarded as the second most popular place of arbitration. And in fact, the arbitral rules have been regarded as the best in Asia, and in fact they rank second together with the Singaporean rules. In other words, we have been keeping a position as the most preferred seat, and in fact it shows that in the relevant market we have an advantage. Well, in relation to the time taken to reach a final award, Hong Kong IAC's performance is good, and in fact between November 1st, 2013 and 30th of April 2023, in fact the time taken is more or less the same with other comparable organizations. On the 1st of March this year, we started to regularize a scheme and refine the scheme. There is a pilot scheme on facilitation for persons participating in arbitral proceedings in Hong Kong. They come as visitors. They don't need a work visa. In this way, we can facilitate Hong Kong's attraction as the preferred place of arbitration. In other words, we are able to get more experts to take part in arbitration. Through the facilitation scheme, we believe that more parties to arbitration will choose Hong Kong as the seat of arbitration, and there will be more business for us. On the other hand, we have been helping the arbitration organizations to explore more opportunities. In fact, the SJ has led a delegation comprising representatives from law society, etc., and the bar association, etc., to go to different places. Like we went to Riyadh in the Kingdom of Saudi Arabia, and Abu Dhabi and Dubai in UAE, etc., so as to promote our business. In fact, we will be we have been rendering a lot of support to the Hong Kong IAC in the promotion of business in March this year. And in fact, we'll continue to work together with the relevant sectors, and we'll be happy to listen to the valuable comments of the lawmakers so that we can work together to consolidate our position as a place for dispute resolution. Thank you, SJ. Next, I would like to give the floor to a number of guest speakers. First of all, from the Law Society of Hong Kong, Mr. Nasher.
Chairman, Secretary of Justice and members of Legislative Council, good afternoon. One of the essential conditions of cultivating world-class law firms and arbitration institutions is to have world-class lawyers. The Law Society of Hong Kong has always been committed to nurturing professional legal talent in Hong Kong. First of all, the self-regulatory role of the Law Society is crucial for training internationally recognized legal professionals. The uniqueness of the Law Society lies in its role as an independent organization. It does not only ensure high standards and professional ethics of the legal profession, but also maintains autonomy from the government while upholding the core values of the rule of law. This characteristic has earned the Law Society of Hong Kong a high reputation in the international legal community. A self-regulatory professional body, the Law Society has established principles that lawyers must adhere to their practice. The Hong Kong Solicitor's Guide to Professional Conduct, Volume 1, published by the Law Society, sets out the basic principles governing the practice of solicitors, including areas such as obtaining instructions, fees, fiduciary duty, confidentiality, conflict of interest between clients, and complaints and discipline. The standards set out in the Solicitor's Guide are those that all solicitors are expected to achieve and adopt in practice as minimum requirements of professional conduct. By maintaining strict regulation, the Law Society ensures that solicitors adhere to high levels of professional standards and professional ethics. The self-regulatory mechanism effectively builds a culture of professionalism and integrity among solicitors, enhancing the confidence of both local and international communities and institutions in Hong Kong's legal practitioners. This is particularly important for cultivating law firms that align with international standards. In addition to basic principles of practice, the Law Society has also set out various practice directions in Volume 2 of the Solicitor's Guide, providing concrete and practical guidance for solicitors in their legal practice. The Law Society continually reviews and updates these principles and practice directions to ensure they keep pace with the international standards. For example, in December 2007, the Law Society issued Practice Direction P, which provided a comprehensive set of guidelines to solicitors regarding the anti-money laundering and counter-terrorist financing financial institutions ordinance. Subsequently, in light of the amendments to the AMLO, the Law Society updated Practice Direction P in September 2018 and May 2023 to ensure that its requirements are consistent with amendments to the AMLO, including compliance with the latest international standards set by the Financial Action Task Force, FATF. Lastly, I would like to mention the Law Society funded the Hong Kong Academy of Law in 2008, a training academy established to design professional training systems and provide relevant training for all members and solicitors. In February this year, the Academy established a Common Law Centre as its training arm. The Common Law Centre is aimed at more effectively promoting practical training in common law and more systematically providing training courses and exchange platforms of legal professions from the mainland and other non-common law jurisdictions. This will help train more foreign-related legal talent from the mainland and Hong Kong, contributing to cultivation of world-class law firms and arbitration institutions, and better reflecting Hong Kong's role as a super connector. We will explore advancing the following initiatives through the platform of Common Law Centre in the future. Firstly, to coordinate the introduction of training courses on the Law Society's supervisory functions and professional conduct, focusing on the characteristics of legal services and market management in the common law area, and to provide training for practitioners from non-common law jurisdictions, including those along the Belt and Road regions, on management of law firms. Secondly, to promote talent exchange in regions along the Belt and Road and deepen collaboration with law firms in various areas. to design practical common law courses for corporate legal departments and management teams. The Common Law Centre will continue to provide popular thematic courses such as comparison between common law and non-common law legal systems, cross-border investments and wealth management, corporate law topics, international commercial dispute resolution, and mock arbitration. Hong Kong has a mature legal system and an internationalized legal environment with efficient dispute resolution mechanisms. Under the principle of one country, two systems, Hong Kong is the only common law jurisdiction in China and the only jurisdiction along the Belt and Road that has adopted and implemented a Chinese-English bilingual common law system. Against this backdrop, the Law Society will continue to ensure a comprehensive management system for law firms through its independent self-regulatory mechanism and will update the need to reflect the latest developments in local and international law in order to cultivate more world-class foreign-related legal talent. Thank you.
Thank you, Mr. Vice President. 下一個團體係
Next, from the Hong Kong Bar Association, I would like to invite Ms. Kim Margaret Rooney, Bar Council member, to speak.
Thank you, Chairman, Secretary for Justice, and members of the Legislative Council. The Hong Kong Bar Association supports the Department of Justice's policy initiatives. As the Secretary for Justice has said, recently in the globally respected 2025 International Arbitration Survey conducted by Queen Mary University of London, Hong Kong's leading role in international arbitration and indeed dispute resolution was confirmed. For Hong Kong to be ranked as the second most favoured legal seat or place of arbitration with Singapore was a great testament to the strength of Hong Kong's legal system and its legal sector. And in addition, as has been said, the rules of the HKRC are the most preferred rules in the Asia-Pacific region and ranked second most preferred rules globally. And not only does Hong Kong have the HKRC, but it has a number of well-respected homegrown and international arbitration institutions based here, including not only HKRC, as I've said, but ICC, EBRAM, CTAC, South China Arbitration Centre, and others. So the Bar has been actively participating in the promotion of Hong Kong law and Hong Kong's legal services, as well as the other initiatives that have been outlined by the Secretary for Justice. This has included participating in the Department of Justice's initiatives, including trainings and delegations in the mainland, Asia and the Middle East, conducting seminars and events in the mainland and Hong Kong in collaboration with other stakeholders, including arbitral institutions, universities, lawyers' associations and others, organising a judicial colloquium during the ICA 2024 conference in Hong Kong, where senior judges from the mainland, Hong Kong and England and Wales talked about supervision of arbitration, and it was displayed what a common theme there is to do with fairness and efficiency. We organised a seminar on funding of arbitration costs and barrister services for lawyers in the mainland at an event during China Arbitration Week in collaboration with CTAC, and we've conducted mock hearings and other trainings in the mainland in collaboration with any institutions and lawyers. The Bar has worked with the Department of Justice and other stakeholders on developing and promoting the outcome-related fee structures, which with third-party funding reforms do provide innovative solutions to cost issues for parties. And as we know, cost is a major challenge in arbitration. And these funding tools are being used, as may be seen from the HKIC statistics. The Bar is committed to developing the skills and expertise of its members, including young barristers, including by education and training, such as with mainland and international arbitration institutions and lawyers' associations, encouraging qualification as GBA lawyers, and arranging and sometimes subsidising exchanges in the mainland and internationally, as well as attendance and conferences. And the Bar is continuing and will continue these efforts in 2025. Thank you.
Thank you, Ms. Rooney. 下一位
Thank you.
中心嘅代表發言。
Hello.
Next. we will have the Secretary General of the ICC. Now, first of all, I would like to very simply talk about our background and some of the developments. HKIEC was set up in 40 years ago exactly. International Arbitration Center. For our positioning had always been clear. We have been handling different types of cases, and in particular, we have a focus on cases which are multi-jurisdictional. And that is to say, for many of the cases that we handle relate to places outside of Hong Kong. And for Hong Kong IAC in cases management and also in arbitration appointment. This will be our main areas of work as well. The center together with the SJ and also for some of the bodies responsible for dispute resolution, we will work together and promote Hong Kong as a hub for arbitration and also the services of Hong Kong IAC. For 2024, these are some of the statistics. Well, last year, we had 352 arbitration cases handled. They come from 510 contracts, and the amount is 106 billion Hong Kong dollars. And there are a lot of multi-jurisdiction cases, and these were over 85% of the cases at IAC involved at least one party coming from outside of Hong Kong. So you can see how international it is. And they come from over 53 jurisdictions around the world. And these consistents have been consistent, and local users would be number one among our users in terms of frequency, and second place would be mainland users. So this is the 2024 statistics for Hong Kong IAC. And the number of cases handled and the amount involved, they have set record highs. And just now, the SJ had mentioned the Queen Mary University of London had done a survey. I will not go into the details, but it would show that for global users, they have a lot of confidence in Hong Kong and a lot of recognition for Hong Kong IAC, and we are very happy to note this and note the development of the entire profession in Hong Kong. And Hong Kong IAC believes that for arbitration in Hong Kong in the future will continue to provide a lot of opportunities for local practitioners. This is seen in a number of ways. First of all, for the cases that we handle at IAC, for the majority of them, they use Hong Kong law as the law for reference law for the contract, and so solicitors and barristers in Hong Kong would be involved. And also Hong Kong as an arbitration hub, this is a very popular choice. Some 97 of the cases actually choose Hong Kong as the seat of arbitration, perhaps using the Hong Kong courts. As for the arbitrators appointed every year, the IAC would publish our data. We can see the breakdown therefrom. Last year, for instance, for the confirmed and appointed arbitrators, a majority of them would be Hong Kong passport holders, taking about 30 to 35%. So these are confirmed and appointed by us, Hong Kong passport holders, so that's 160 individuals. Another piece of statistic for mainland arbitrators, that would take up 7%, so that would be among the top 5 ranking jurisdictions. Now for cases, 80% of the cases use English as the language for proceedings, and 20% are Chinese. So especially for Hong Kong, with arbitrators and legal professionals fluent in the 2 languages, this is definitely a very big advantage. Every time we do promotions, we want to see that the parties to the contract would choose Hong Kong as to choose Hong Kong law in their contracts, and also the venue of dispute resolution would be Hong Kong. And in reaching this goal, we will need both parties to the contract to agree to the venue of arbitration and also the governing law, being Hong Kong law. And in this, there are a few things to note. Our local market is important. Our local professionals, our lawyers, our arbitrators, that's very important. And the second important point as a market is the China mainland market. A lot of mainland companies want to go out of the country, and therefore we want to we do a promotion in the mainland as well. And thirdly, in the international market, we do promotions as well. The mainland corporations, when going out into the international arena, they would also want the counterparts internationally to agree to using Hong Kong as a venue for arbitration. So in the past, we have been promoting mainly in the European and the US market, but lately we have been more diversified. In the past couple of years, we have been going to Southeast Asia, the Middle East, Latin America, and Africa as well. We are very proactive in these markets as well. So to develop further the arbitration service in Hong Kong, there are a few focuses for us. One, the case management. We have to upkeep that quality, including we have to be very neutral, professional, efficient, and creative. So these are our focuses. A second point is in promotion. I just want to give you a few examples here. For the mainland of China, for instance, recently a big development would be with the support of the relevant authorities in the mainland and also in from Hong Kong, including the DOJ. We have set up a base in Beijing to enhance communication and also to be the bridging Hong Kong lawyers to the mainland and allowing more people to know about Hong Kong legal services. And also for promotions where mainland lawyers come to Hong Kong, we would receive them very proactively and explain the services that we have in Hong Kong. And at the same time, we organize a lot of seminars, including the ICA Forum, with 1,400 participants coming from 70-odd jurisdictions. And we proactively work with other dispute resolution institutions on these. And outside of Hong Kong, we go out and do promotions, including mainland China. We do a lot of training for arbitrators, for lawyers, etc. And also we represent Hong Kong in other international fora. And we work together with the DOJ in a number of ways, with the SJ leading the delegation going to ASEAN countries, etc. We have always been very proactive in supporting those as well. Well, thank you, HAIAC, for telling us about your work. And next, we will have Dr. Thomas So, Chairman of IBRAM International Online Dispute Resolution Center. Well, members of the government, honorable members, and ladies and gentlemen, I'm very happy to have this opportunity to talk about how we can nurture more first-rate world-class law firms and arbitration institutions. As chair of the Institute, in arbitration and also in legal tech, I want to share certain views, and this has to do with dispute resolution. These are key, actually, I would say. Hong Kong, as an international dispute resolution center, Hong Kong had always been a popular choice for arbitration because it relies on a very strong legal basis, independent judiciary and also common law system, as well as being bilingual. And sitting next to me, Hong Kong IAC, we were talking about various associations, including those involving other countries, Middle East, Africa, and also, of course, our country. And also, recently, there is a South China arbitration which had also been had set up base in Hong Kong, and also recently the Shanghai Arbitration Institute has also set up base in Hong Kong. So in terms of business, Hong Kong is promising. When we see these arbitration institutes coming to Hong Kong to set up base, they actually have different focuses. We all work together to make Hong Kong an international world-class arbitration and dispute resolution center. But things change very rapidly. Hong Kong's system and institutions will have to move together with the times. Fine traditions, of course, will have to be maintained, but what is more important is that we have to be continually updating ourselves and also being innovative. And in particular, we are encouraging entrepreneurship, some of the new SMEs, their digitalization, their cross-boundary disputes. This is a new area for dispute resolution. In setting up, we wanted to provide safe, efficient, and cost-effective online arbitration, ODR, we call it. And at the back of it is our proprietary technology. And we are the only one B2B APEC-appointed supplier for online arbitration and dispute resolution. And for the 9 recognized institutes for dispute resolution, we are one of them. For ODR, apart from online, in our development, we have also incorporated legal tech. In our platform, we have provided this to the SMEs so as to facilitate them in their business and also cost-effective service providing to them. All these testify to our institutions being able to go successfully into other markets, including the mainland China market. Now, in face of some challenges, we have the following observations. First of all, nurturing of professionals. In order to have a talent pool that is sustainable, we have to nurture professionals who are familiar with legal tech and also trained in arbitration, who are familiar with the operation of ODR. And the government should continue to support these schemes of training and also provide opportunities of cross-boundary or cross-border exchange so that there is more practical experience for arbitrators and dispute resolution personnel. And further, we have to continually optimize our legal framework and continue to innovate so that online and platform-based dispute resolution can have more clear directions. And to clarify, for example, e-signature, the legal status of that, and also to strengthen the capability to use omni-channel, that is online and offline flexible facilities for dispute resolution, and promoting internationally first-rate law institutions, of course, will have to be able to serve the local and attract the overseas. So along the Belt and Road areas, ASEAN countries, and also APEC supported cloud-based dispute resolution. All these are efforts of ours. And further, we have to promote Hong Kong as a dispute resolution center. We have a few proposals to make. One, in policy and in positioning, the government should be clear in continually promoting and supporting arbitration institutions with unique positioning, for example, online and legal tech and assisting digitalization of SME operations. And also in certain specific areas where there are disputes, there will have to be further promotion of services. And also the arbitration market around the world, including that of Hong Kong, there should be specific arbitration institutions set up to target different sectors so as to enhance the protection and efficacy of the services. And also there should be alliances with EU, ASEAN areas so that there can be a certain guidelines or model law or model rules for online arbitration and dispute resolution so that this can further develop as a profession. And further, funding, of course, is important. Online arbitration will need funding and investments. We hope that the government will continue to fund R&D for hardware and software in this regard, and also to support the institutions to handle the latest in technology and also to enhance the competitiveness of digitalization. Now, overseas, such as Singapore, they want to build themselves up as a hub for legal services. Hong Kong can also set up organize conferences for online arbitration and legal tech for perhaps once or twice a year, and also going out of Hong Kong to other countries to talk about our latest development in legal tech, to do promotion, and also to provide incentives for international organizations to use Hong Kong as a venue for arbitration to build up the cooperation. A lot of people have talked about that. I'll not go into details in this regard. So in Hong Kong, I think we have a very strong basis, but in order to be continually in the lead, we have to be flexible, we have to be visionary, and also we need to continually invest to use new modes to provide arbitration by providing technology and to open up new areas of practice.
Thank you, deputations, for providing a lot of valuable comments. I think 5 minutes each for the Q&A. The first to speak, Professor Priscilla Leung. Thank you, Chair. For the government, the two legal bodies, as well as the Hong Kong IAC, well, in fact, you have worked very hard and you have made achievements in relation to allowing Hong Kong investor enterprises to adopt Hong Kong law, as well as the allowing Hong Kong investor enterprises to choose Hong Kong as the seat of arbitration. I have to declare interest. I'm on the Hong Kong International Legal Talents Training Academy. I'm also an arbitrator of the Hong Kong IAC. I'm also a professor of the Hong Kong City U. And I oversee the establishment of the law school at CU Hong Kong, as well as that in the City U. Let me talk about the overall sort of atmosphere. Trump, he started the tariff war, and it has brought along a lot of repercussions. But for you who are familiar with the American lawyers and international lawyers, well, in fact, they're telling us that the better the universities, the more they are suffering from the suppression from Trump. And in fact, international law firms are being sort of pressurized. For international law firms, if they help certain clients on a pro bono basis, I also took part in overseeing this, the American government would threaten them that is, important subsidies would be denied. They will be denied of the important subsidies, significant subsidies. I think the nation of the USA is torn apart. And in the United States, they have got lawyers from all over the world. So what happens is that Hong Kong has a godsend opportunity. President Xi said that we need to have technology and talents. It isn't a matter of talents in the tertiary institutions. For the legal talents, they have been dealt a heavy blow. Well, at this stage, of course, we know that we have got many international lawyers in the United States. Perhaps when we try to fight for legal talents, we should aim at such talents. They may be very outstanding in particular areas of the legal field. Now, even Americans are fleeing to countries like Canada. If we can get them over to Hong Kong, it shows that under one country, two systems, we are open and we are tolerant. Touch wood, it won't happen. Prior to the Second World War, many scientists fled Germany. They went to the United States. Of course, I don't want to comment on what's happening within the USA. But then when it comes to the fight for talents, we shouldn't be slower than France. The French president welcomed the scientists and other talents with open arms. For us, we need the most talented lawyers. Recently, there was an expert in mining of the seabed. Well, Trump, as a result of an administrative order, allowed for mining of the seabed. I think we should try to poach all sorts of talents. We should attract them to come over to Hong Kong. For law firms in Hong Kong, I think we have a golden opportunity. For such talents, they are very depressed and they haven't encountered such difficulties in the past. They should become the targets. They should become our sort of targets, and we should attract them and ask them to come over. So today we are talking about first-class law firms. For the law schools, of course, we should try to get as many first-class professors as possible. For the Ivy League universities, they are being suppressed by Trump. So for law schools, we have our task. We should be as open and tolerant as possible, in particular in areas that we lack the talents. For the Middle East, Russia, Africa, etc., there are many business opportunities. And we have the low altitude economy. Again, we need experts. For the mainland, they may find the topic oversensitive or very sensitive. In Hong Kong, we practice common law. Well, to be frank, I've been teaching at a university for 33 years. Are we able to nurture sufficient talents with a short period of time? Of course not. But then the whole world has been thrown into a chaos. I think it's better for us to gather the talents, and then we can have not just mainland lawyers. We will have talents from different sources to fight together. So in this way, we won't lose out to countries like Singapore or other countries that have statute law as well. So I just want to say that given the international background, and since we have already set up the Hong Kong International Legal Talents Training Academy, we should try our best and deploy different means to attract the international legal talents to come here. There are lawyers who have got French qualifications and American qualifications. Some of my students have got a French qualification. In this way, they can have business from France, and they set their eyes on the mainland as well. So that's all I want to say. Anything from the administration? I thank Professor Leung for her comments. Next, Ms. Maggie Chen. Thank you, Chair. Thank you for having this topic for our discussion. Well, we have got an excellent paper from the administration on the cultivation of international first-class law firms and arbitration institutions. So law firms and arbitration institutions, and we don't have a lot of time, so I would rather focus on law firms. For the purpose of the paper, it doesn't talk about how to strengthen our law firms. And in fact, in paragraph 3, you haven't given us any figures concerning the number of law firms. You did tell us about the number of solicitors or the number of barristers, but what about the number of law firms? How many of them are sole proprietorship? How many of them are partnership, having 2 and 5 members or 2 and 5 partners? In the absence of such figures, it means that they haven't taken a broad view as to our legal sector. That is, the landscape as well as the development of our legal sector. They lack the figures, they lack the information, and therefore, naturally, they don't have any information as to how they will help to strengthen the partnership firms having between 2 and 5 partners so that they can become first-class law firms. So I'm afraid the paper is incomplete. You have missed out the part concerning law firms, and you haven't told us that for the sole proprietor firms, which account for 45% of the law firms, as well as the 35% partnership firms having between 2 and 5 partners. You haven't touched upon the development of such law firms. Probably you will ask me to go to paragraph 20, and that's in relation to medium and small size law firms. But I think you have missed out on the law firms. Probably you only lightly touch upon the fact that 45% of the law firms are sole proprietorship firms. You talked about the self-regulatory nature of our regime. You also said that for law firms, for the development of law firms, there's the idea of solicitors corporation. But then the paper also says that it will be by way of negative vetting. What I want to highlight is that for the administration to look at the development of law firms, you haven't got dedicated policy to help the medium and small size law firms. For the self-regulatory regime, I'm grateful to the Law Society, and Ambrose has touched upon that. For you to encourage law firms to have incorporation, to form solicitor corporation, I can see the advantages. But of course, other than the benefits, there are also disadvantages. You have to bear both in mind. You can't rule out the possibility that by encouraging the mergers, the larger firms will get stronger and larger, and smaller firms will become very small and even weak, and they won't have any bargaining powers. I think no one here can rule out the possibility that the larger firms will take over the smaller ones. For us to have a well-balanced exercise, on the one hand, we want to provide more choices when it comes to the mode of practice. On the other hand, you have to prevent the taking over of smaller firms by larger firms, and sort of a merger being forced upon the smaller firms. You have to make sure that the smaller firms would not be forced to be taken over or to be merged with other firms. To me, I think the policy of the government and the fact that the government allows for self-regulatory regimes to continue, I think the government has not been taking care of the legal sector in a good enough manner. I would urge the SJ in particular. Though I know you have been working hard, it is a very long-standing and difficult issue. In particular, the paper exposes your mindset. It shows that the thinking is incomplete, and I hope that the SJ as well as his colleagues will work hard and work together to provide some improvement to the issue.
Now we're looking at the annex of the document. There is a survey there. And I thank the chairman for providing us the survey. But since this is an appendix, as far as I understand, to the document of the meeting, I would like to know what is the background of the organization doing the survey. This is the integration into the national fund, it seems. Page 30, it talks about the superstructure. And it says that basically the argument is that the small to medium-sized legal firms should merge so as to make the scale bigger. Well, there are advantages and disadvantages to that. As I've mentioned just now, I'll not repeat myself. Now, the documents together with this survey taken together, I think for those victims, they would be the 45% of practitioners, the sole proprietors. They will be eaten up. They will be bullied by the bigger law firms. And in the end, there will be scarcely any room for them to operate. And in the end, who will suffer? The entire profession in Hong Kong. Now, there are two law firms which have been reviewed, and these are not small to medium-sized law firms. They're not in the 45%, I would assume. Sorry for having taken the time, but basically I would invite wisdom and views, and let's work together. Chair, just to clarify, the survey is actually provided by the chair. We, that is the DOJ, had not participated in this survey. So I just want to point that out. Right. Maggie mentioned the small to medium-sized legal firms just now. I know this is a focus of Maggie's. And in the paper, I talk about the sole proprietors or 2 to 5 lawyers, firms, and this is from paragraphs 2 to 9. We've mentioned these firms. As of 31st of March 2025, there are 417 sole proprietors with 399 2 to 5 partners firms. Now, following on Maggie's opinions, we fully see that going forward, what is the development for the profession? There are different views even within the profession. So what is the position, role of DOJ? Now, Hong Kong, with our common law system, for the profession's development, the leadership role is taken up by the two professional bodies. And this takes internal communication to find the best way forward. We are proactively coordinating and perhaps guiding the profession for effective communication and discussion. For example, the professional development of the professions. Together with the professional bodies, with the courts, we are conducting such discussions. But on the other hand, there is this division of roles among the different entities. As DOJ, we will for sure more proactively find the way forward together with the professions. This is good for all. Even the different law firms have different ways of looking at themselves. Some like to be sole proprietors. They have to serve the community or some clients with close relationship. So how do we coordinate all this it takes input from all sides. And those who are thinking hard about this topic, let us put our heads together so that it will be beneficial to all. So in answer to Maggie's question, yes, we'll be putting in more efforts in this regard. Well, we hope that in this very difficult operation environment and where costs of operation is so high, let us avoid the situation of the small firms being eaten up by the large ones. Now, to nurture first-class law firms and arbitration institutions is a national policy. First-class law firms need not necessarily be large. They can be very specialized. There can be small to medium-sized law firms which are very excellent and specialized. So we need an independent arbitration institution, and it's through open tender. The LegCo, well, myself as a LegCo member, I have forked out the necessary cost to do this particular survey to find out the SOEs, the state-owned enterprises, what kind of legal service they need from Hong Kong. And in that midst, even small-scale Hong Kong law firms can provide that service. Actually, as long as you have excellent service, if you're specialized, I'm sure international companies, corporations will be happy to use the service. So not necessarily large law firms would be given that opportunity. All right? Yes, let us extend the meeting by 15 minutes. Next to speak, Holden Chow. Thank you, Chair. Chair, you have shared this document today, and thank you for the explanation just now. And the DOJ had also made their clarification. And I would like to take this opportunity to express my opinion. And we are facing a core issue still, and that is 45% or more, or 46%, as pointed out by the document, are sole proprietors. And I myself also run a sole proprietorship. And the Secretary pointed out very rightly just now, some lawyers want to remain sole proprietors. Why? Now, if you have read the survey report, well, thank you again, Chair, for sharing, but sometimes we have different points of view. I fear that while you're reading the report, you would think that, as my colleague Ms. Chan said, this is a scenario where the large firms will eat up the small firms. Well, not everybody sees the same. I just want to point that out. Now, the survey is very detailedly done. But I just want to say that actually in Hong Kong, for the legal profession all along, there had been opportunities for small, medium, large firms targeting different market sectors. Even the sole proprietors one-man ban, which is some 45% of legal firms in Hong Kong, they are taking up a lot of cases that take place in the community, litigation for divorce, estate management, personal injury, certain criminal cases, etc., etc. Honestly, for this kind of work, it really relies on the small-scale firms, the sole proprietors. You know, for the average bloke, for the average person, how can they afford the service of large firms? Now, even for state-owned enterprises of the central government, etc., we all understand they all will have to go to firms of a certain size to go IPO, etc. So the Market segmentation is completely different. So don't force the issue. And you can't do that anyway, because for each of the levels, there are market sectors served by the different types of firms, the small, the medium, and the large. And I don't want to see the situation where one day even the man on the street will have to go to the large firms for their legal problems instead of having sole proprietors to go to. So that's very important to note. A second point, I personally feel that for Hong Kong legal service, we see a lot of small firms, as mentioned just now, sole proprietors, for instance. In our actual practice, for many of these small firms, they're very specialized, very professional. They are not necessarily working with the large firms or with some of the major corporations from the mainlands, but they provide excellent service nevertheless. They just want to focus on what they're good at, that's all. So everybody's providing different services, providing service to different levels of the market. I don't want to see, after the discussion today, there is a misunderstanding saying that there is an encouragement of the small firms or sole proprietors to merge, or those with 2 to 5 partners should not survive. So this is definitely not the direction of this panel. And I'm very glad that the Secretary had made the clarification. You hear different views. And as a member in the profession, even as small firms, some of us have been doing excellent work. But as I've mentioned, they serve different segments of the market. And there's more room for further development. There may be something new. There may be new areas of service provided by these small firms, and that is important. Do not emphasize the possibility of big firms eating up the small. And another point, why there are so many sole proprietors? You understand, for us in the legal field, it's very difficult to partner up, because the legal profession is provided by you. Your partner may not agree, and the divvying up of costs and revenue would be problematic as well. There are reasons why there are so many sole proprietors. I just want to convey that point. No need to respond. Thank you so much. Well, there is time to respond. We have to clarify.
Well, when it comes to legal services, we have to be diversified. We should be able to meet all sorts of needs, whether it is a grassroots client. Well, we have to meet the needs of those at the lowest level by grassroots clients. At the same time, we need to address the needs of the topmost echelon. Irrespective of the nature of the needs, we hope to achieve the following. That is, we'll be providing a diversity of quality services. So there may be different areas, different fields of professional service. Now, what we want to make sure that we can still be providing the best service. We like to provide like in the case of a garden, if I can draw a comparison, we are providing the best soil so that we have different types of flowers blossoming, and then the clients will be able to look for the most suitable lawyer. Now, different lawyers have different expertise. A lawyer may be best at running a sole proprietorship, and he or she may still be interested in providing service to the grassroots citizens. So we want to enrich the number of choices so that we have diversity in the services. But we would like to have topmost quality at each and every level. Next, Ms. Carmen Ken. Thank you, Chair. I need to declare I've been practicing, and I've always been working for international law firms, and then I became an in-house counsel. Currently, I spend most of my time in this council. Well, when we look at the professional development of the legal sector, then I will agree with the SJ. That is, we always have self-regulatory regimes. Now we have the two legal bodies present and we have the arbitration organizations here. I think the professionals should be allowed to regulate themselves because they know their own case best. Now for the paper from the administration, I think the paper shows that the government has done its best, providing the platform, providing the policies, making amendments to the laws, and then leading delegations on mission trips. So they are facilitating our development. What about the challenge or the challenges? The room for development is different and smaller. We used to connect the mainland with the rest of the world. So probably in the past, we talked more about FDI, overseas investors investing directly. Now, the mainland enterprises would like to go overseas. And we mustn't forget the international landscape. In the past, they might be going to the USA and to the European countries. Nowadays, they go to the Middle East, they go to elsewhere. And then just now, Ibrahim also talked about the need for knowledge of other languages or the minority languages. Some law firms might have downsized. But then just like our economy, we are undergoing a transformation stage. And then the cost, the operation cost is also falling. So let's give the sector time. The topic of the paper is cultivation of first-class law firms and arbitration organizations. I think we can still keep our status. For the Hong Kong IEC, I think we've been told that the caseload has reached the peak. And for ODR, I think Ibrahim has done a good job. Probably they have been relying on AI to help them with the translation of minority languages. So perhaps arbitration organizations shouldn't act on their own. They shouldn't have their own platforms. I think it's better for us to be connected and we should have collaboration. So if I want to ask a question, I want to ask the SJ this question. You would like to have a specific platform for the GBA lawyers. What actually have you got in mind? And what about the Law Society and the Bar Association? How can they work together on such a platform to synergize? So that's my first question. The second question is, now we are very unique, and this is mentioned in the paper. We are able to have preservation in arbitration, and we can have mutual recognition of the judgments. But of course, the media may say that this is not good, this is a sort of disadvantage. However, we have been told that we should try to open up new markets, and we should also make good use of allowing Hong Kong law to be relied upon in the case of Hong Kong invested enterprises, and we should allow Hong Kong invested enterprises to choose Hong Kong as the seat of arbitration. SJ, well, for this dedicated platform for GBA lawyers, let's look at the figures. For those who have become qualified, I think there are 550 of them. We have talked to many of them. They have got this difficulty. They are qualified, but how are they going to establish their themselves on the mainland? So what is needed is that we need to let the GBA know who is qualified. So we need a platform so that they can know who is a qualified GBA lawyer. Sometimes, even though you have got the lawyer's license, you may not know where to find your business. Therefore, we want to have this platform so that lawyers who have passed the exam and licensed can have an opportunity to know the GBA law firms. In other words, as Carmen has said, we are facilitating the task so that we can have mutual trust, and then in the long term there will be cooperation. It takes time. We are providing the opportunities by setting up this platform. We are in the process of getting this platform ready. As to how the platform can be put to better use, we will benefit from your comments. What we are mindful about is that we want the qualified lawyers to get the opportunities. So you would like to have a platform to let the client organizations understand that we have, say, 550 GBA lawyers, and we want to sort of tell the potential clients the expertise of such lawyers. Well, as to the survey, perhaps today isn't the right time, but then I want to know about the next step. Can we have some replies from the administration? Now, for the GBA platform, that's for individual lawyers, but what about other platforms? Well, if members do not object, can I further extend the meeting by another 15 minutes? Otherwise, we have to stop by 6:45. Probably we don't need all the extended duration. The next to speak will be myself. Now, this paper is about the cultivation of international first-class law firms and arbitration institutions. Well, it is one of the important national policies from the third plenary meeting of the 20th Congress. So I agree with the SJ. We should provide fertile soil for the law firms so that they can develop themselves into international first-class law firms. I've also mentioned that first-class law firms don't always have to be large law firms. Small law firms can also be international first-class law firms. Professor Leung also mentioned about the need to get the legal talents. Like other jurisdictions, medium and small law firms account for the majority of the law firms. On the mainland, this is true as well. But at the same time, they have also got law firms with thousands of members. I think this is because we have a different background, the society is different, the rules and regulations are also different. So perhaps we should look at our own characteristics. I don't think it is always a matter of merger and larger firms taking over the smaller ones. I've seen for myself over the past few decades as to the barriers preventing the growth of the law firms. First of all, the liability of partners in partnerships is unlimited. And then we have got the title of the law firms. Where we need to have the law firms have to be named after the partners or the previous partners. On the mainland, they don't have the same rule. As long as you don't have any absurd or inappropriate names, and then you will be fine. So I'm afraid the naming restrictions have become a barrier as well. So I just wondered if we can have a breakthrough and try to remove such restrictions. We have a self-regulatory regime, and professional development is also the duty of the legal bodies. But then, if the cultivation of international first-class law firms and arbitration institutions It's a national policy. Perhaps we should think afresh and try to see how law firms can merge more easily and how we can try to provide better services. SJ, I can totally agree with why you chose this topic. If I remember correctly, I think for foreign-related legal business, cultivation of international first-class law firms and arbitration institutions is an objective. Under one country, two systems, would like to help with the further opening up and reform of the motherland. And by relying on our existing strength, we can help. But of course, we have to find ways to improve ourselves. Chair, you wondered whether there's room for further deregulation and breaking down of the restrictions so that we'll be more facilitating. Of course, we'll be more than happy to be a facilitator. Say, for example, there are two issues. Partnership may cause difficulties in mergers. I think, Chair, you have mentioned that perhaps the solicitor incorporation should be launched. The government as well as the Law Society have been working on this, and we have got some concrete results. And I believe that this can be launched. Many conditions are already ready, but of course there's still certain steps that have to be gone through. But Chair, you know that we have been following this up. As to the question of naming of the law firms, to be frank, I'm not sure whether this is an issue, but if the sector tells me that it is, I will regard it as my duty to help you to resolve this problem. Thank you, SJ. Next, Ms. Maggie Chen, the second time. Thank you, Chair. Well, I have to declare interest. I'm a GBA lawyer, I'm a local lawyer, I'm also an arbitrator and mediator in the GBA in Hong Kong. I'm also the founding chairman of the Association for Medium and Small Law Firms in Hong Kong. There's so many experts in arbitration. I have to say the following. There may be amendments to the arbitration-related laws on the mainland. Now, for Hong Kong, we are internationally renowned for our arbitration service. Well, in fact, I believe that as an NPC delegate, I think we should make sure that arbitration should be further developed, and the arbitration experts here can help a lot in the development of arbitration of the PRC. I'm grateful to EBRAM. Well, they have given a definition, and I know about the functions. They will be training up lawyers, and they will render help to the medium and small size law firms. It is good. It helps us to be updated. As to the self-regulatory framework and professional autonomy, yes, we are proud of it, but it doesn't mean that the policy should leave everything to the two legal bodies. I'm sure the SJ hasn't got this mindset, but when it comes to policies, I think you need to be more proactive to help the sector. In particular, 45% of the law firms are sole proprietorship. Well, I think that's all I want to say. Sorry. SJ, anything to say in reply? Maggie, you don't need to worry. I'm mindful of all the worries that you've got in mind. We have been listening to the sector. We have been having more dialogues with the sector so that we can listen to you, and then we can find ways to help you to meet your needs. So I hope I can play this role as to communication. Certainly, I will do more by having more communication. Thank you, SJ. I think that's the end of our discussion of this topic. Anything under AOB? If not, then I will say that meeting adjourned. Thank you.